We have witnessed history. For the first time ever, Congress has criminally referred a former president for criminal prosecution. Even Nixon and Andrew Johnson were never referred to the Justice Department for criminal prosecution. But what does this mean? What is a criminal referral? And what was the January 6th committee basing its findings on? Well, throughout the January 6th committee's hearings this summer and fall, the committee has presented evidence of Donald Trump's attempt to remain in power despite tens of millions of Americans. More importantly, 306 real members of the Electoral College, which are more important than millions of Americans, saying no. They've also presented eyewitness testimony and depositions about the way that Trump's deranged insistence the election had been stolen resulted in an armed and deadly insurrection on the Capitol building. The committee interviewed Georgia Secretary of State Brad Raffensperger about his perfect phone call with Donald Trump. Raffensperger testified that Trump called him asking him to find 11,000 ballots to help flip Georgia from its blue reality. The committee heard testimony from a slew of White House and other government officials that they had told Trump that his election denial stuff was absolutely not correct, but that Trump totally ignored and disregarded their pleadings. There was memorable testimony from 26-year-old aide to Chief of Staff Mark Meadows, Cassidy Hutchinson, who testified that Meadows suggested he knew beforehand about the insurrection that would happen on January 6th.
I found Mr. Meadows in his office on the couch. I remember leaning against the doorway and saying, I had an interesting conversation with Rudy, Mark. Sounds like we're going to go to the Capitol. He didn't look up from his phone and said things might get real bad on January 6th.
She also testified that Trump wanted to give armed protesters entry to where he was giving his speech, so much so that he demanded all metal detectors or mags be removed from the area.
He was angry that we weren't letting people through the mags with weapons. I overheard the president say something to the effect of, let my people in, they can march to the Capitol from here.
Of course, there was also the ketchup anecdote.
I left the office and went down to the dining room. I first noticed there was ketchup dripping down the wall, and there's a shattered porcelain plate. The president was extremely angry and had thrown his lunch against the wall.
But in the final public hearing of the January 6th committee, Benny Thompson and the other 8 members of the bipartisan group laid out arguably the most damning evidence of both Trump's apathy towards the 2020 presidential election and Trump's thundering silence for 187 minutes while insurrectionists overran the Capitol. Trump's White House counsel, Pat Cipollone, and Hope Hicks testified to Trump's silence during the insurrection.
So are you aware of any phone call by the President of the United States to the Secretary of Defense that day?
Not that I'm aware of, no.
But make no mistake, though, Trump was definitely busy strengthening his case for Section 1512 and 1505 obstruction.
The president was making phone calls that afternoon, but they weren't to law enforcement officials. Rather, President Trump continued to call his lawyer, Rudy Giuliani. Both President Trump and Mr. Giuliani spoke with congressional leaders to encourage them to continue delaying the session.
Finally, the lawyers in the Trump White House testified about his Nixon-esque plot to replace the Attorney General with a brazen sycophant.
President Trump tried to install a loyalist named Jeffrey Clark to lead the department as acting Attorney General.
Now that's just skimming the surface for some of the evidence that the January 6th committee unearthed and presented in support of their criminal referrals. But what is a congressional criminal referral? Well, a criminal referral is a recommendation from a congressional committee to the Justice Department that, based on certain evidence, the committee believes that people committed certain crimes. When Congress makes a criminal referral, it has no legal weight. The Department of Justice does not have to file criminal charges just because Congress made a referral. Congress makes law and the executive branch enforces it. But that doesn't mean that the referral is just Congress handing the DOJ a thick file and saying, good luck. It is, as we all know by now, unprecedented for Congress to say that a president committed crimes. The committee's recommendation puts more pressure on the Justice Department and Special Prosecutor Jack Smith to go forward with a prosecution. And the Special Prosecutor statute requires Smith to explain the basis for whatever action he takes, including if he declines to prosecute Trump. But no doubt the Department of Justice is going to be less interested in the ultimate recommendation of Congress and more interested in the evidence that the committee has gathered. So let's talk about the criminal referrals that were made of former President Trump. Representative Raskin said that the 4 statutes that are named here are not the only laws that former President Trump potentially violated, but they are the most important ones. The first is a count of obstruction of an official proceeding under 18 U.S.C. 1512, which makes it illegal to corruptly obstruct an official proceeding. The committee report concluded that Congress's joint session to count electoral votes on January 6 was an official proceeding under Section 1512, and the report relies on the decisions of the many federal judges who have already reached this conclusion in cases involving the January 6 defendants. defendants. As for whether Trump had the requisite intent, the committee concluded that, quote, there should be no doubt that President Trump knew that his actions were likely to, quote, obstruct, influence, or impede that proceeding. And based on the evidence developed, President Trump was attempting to prevent or delay the counting of lawful certified electoral college votes from multiple states. Quote, President Trump was directly and personally involved in this effort, personally pressuring Vice President Pence relentlessly as the joint session on January 6th approached. Quote, indeed, in an email exchange during the violence of January 6th, John Eastman admitted that President Trump had been advised that Vice President Pence could not lawfully refuse to count votes under the Electoral Count Act, but once he gets something in his head, it's hard to get him to change course. In addition, President Trump knew that he had lost dozens of state and federal lawsuits and that the Justice Department, his campaign, and his other advisors concluded that there was insufficient fraud to alter the outcome. President Trump also knew that no majority of any state legislature had taken or manifested any intention to take any official action that could change a state's electoral college votes. And the effort to pressure Mike Pence is just one possible violation of 18 U.S.C. 1512. The committee said that there is also evidence to support charges, quote, based on the plan to create and transmit to the executive and legislative branches fraudulent electoral slates, which were ultimately intended to facilitate an unlawful action by Vice President Pence to refuse to count legitimate certified electoral votes during Congress's official January 6th proceeding. In addition to the fake electoral slates, the committee found evidence that Trump may have illegally pressured state election officials, state legislators, and others to, quote, alter official electoral outcomes. And finally, the report also says that Trump tried to corrupt the Department of Justice, citing his commitment to the DOJ that all it needed to do was, quote, just say that the election was corrupt, plus leave the rest to me and the Republican congressman. The committee also uncovered evidence that Jeffrey Clark was instrumental in trying to corrupt the Department of Justice and further into the scheme to interfere with the official proceeding of Congress to certify the vote.
Jeffrey Clark was an assistant attorney general, a Trump appointee at the Department of Justice. According to multiple sources, Mr. Clark was asked by then President Trump to take over the role of attorney general, in part so he could issue a series of letters falsely suggesting that the Department of Justice believed the presidential election may have been stolen. Of course, this happened after the department had repeatedly informed President Trump that his allegations of a stolen election were not true and were not supported by the evidence. And this happened after dozens of courts had ruled against President Trump and his election fraud claims.
Clark sent the letter that Cipollone described as, quote, a murder-suicide pact in the hope that it would, quote, help persuade a state legislature to change its certified slate of electoral college electors based on false allegations of fraud, which was then supposed to inspire Pence to count a different slate on January 6th. And according to the committee, the letter was transparently false, improper, and illegal. And in terms of the actual Capitol riots, the committee says that Trump's action and inaction during the January 6th riot was more evidence of intent to obstruct Congress. He spent 187 minutes refusing to take any step to stop the violence, and instead Trump and Rudy Giuliani called members of Congress who were sheltering in place to hide from the attackers and asked them to go along with the illegal Eastman plan and impede the vote. And the committee said that John Eastman and Kenneth Chesebro were instrumental in the conspiracy and that Representative Scott Perry and other Republicans who have resisted testifying likely have material facts regarding Trump's plan to overturn the election. The second count of the criminal referral deals with conspiracy to defraud the United States. Section 371 of Title 18 makes it illegal to enter into a criminal conspiracy to defraud the United States. The Supreme Court has held that this statute criminalizes the use of deceptive practices in connection with any conspiracy for the purpose of impairing, obstructing, or defeating the lawful function of any department of government. And conspiring to obstruct a joint session of Congress from certifying the election certainly qualifies as seeking to obstruct a lawful function of the government. And the committee generally alleges that Trump and his co-conspirators followed a 7-point plan. First, engage in a concerted effort to spread false information to the American public that the 2020 election was stolen. Second, to orchestrate a corrupt scheme between Trump Chief of Staff Mark Meadows and Representative Scott Perry to replace the acting attorney general who rejected Trump's fraud claims with Trump's DOJ ally Jeffrey Clark to use the Department of Justice to overturn the election. Third, to implement Eastman's plan to pressure Vice President Pence to refuse to count or delay the certification of the electoral count. Fourth, to pressure state election officials and state legislators to change election results. Fifth, to instruct Republicans to create false electoral slates in 7 battleground states and transmit those fake slates to Congress Congress and the National Archives. 6th, to summon up a mob in the US Capitol. And 7th, during the attack on the Capitol, to ignore pleas for help and tacitly endorse the violence, including threats to hang Mike Pence. As for proof that individuals used deceitful or dishonest means, the committee says that there were 2 areas where Trump and his friends were deceitful, starting with their insistence the election was fraudulent and that Trump defeated Joe Biden. There's actually an incredibly damning chart on page 17 of the committee's report outlining what the lawyers were saying, that there wasn't election fraud, versus what Trump was saying, that there was mass election fraud. For example, Trump showed then Deputy Attorney General Jeffrey Rosen a videotape that supposedly showed a suitcase full of ballots. Rosen explained to Trump that this was actually, quote, a bin. That's what they use when they're counting ballots. It's benign. 1 week later, Trump repeated the conspiracy claim, quote, there is even the security camera footage from Georgia that shows officials telling poll watchers to leave the room before pulling suitcases of ballots out from under the tables and continuing to count for hours. Attorney General Bill Barr and Deputy AG Richard Donahue debunked Trump's Michigan and Pennsylvania voter fraud claims, but once again, Trump ignored what they were saying and made up his own facts. Trump followed the same pattern with other conspiracy theories about Dominion voting machines. And as to motive, the committee says that first of all, it helped Trump raise money. Quote, evidence gathered by the committee indicates that President Trump raised roughly $250 million in fundraising efforts between the election and January 6th. These solicitations persistently claimed and referred to the election fraud that did not exist. And the second reason Trump lied about election fraud was to obstruct the January 6th certification proceedings. Quote, Trump disregarded the rulings of the courts and rejected the findings and conclusions and advice from his Justice Department, his campaign experts, and his White House and cabinet advisors. He chose instead to try to overturn the election on January 6th and took a series of very specific steps to attempt to achieve that result. And this is all related to the third element of a conspiracy, that the person takes at least one overt act in furtherance of the conspiracy. For Trump to achieve the desired result, he had to get Mike Pence to ignore the constitutional duties. You might recall that the 12th Amendment gives the vice president, in their role as the president of the Senate, the job of certifying the result of the presidential election. Quote, the president of the Senate shall, in the presence of the Senate and the House of Representatives, open all of the certificates and the votes shall then be counted. The person having the greatest number of votes for president shall be the president. The Electoral Count Act of 1887 reiterates that the vice president's role is ministerial, in that his job is just to count the votes, not to choose which votes to count and which to reject. But while Trump was being told that he lost the election, lawyer John Eastman and others, quote, devised a plan whereby Vice President Pence would, as a presiding officer, declare that certain electoral votes from certain states could not be counted at the joint session. John Eastman knew before proposing this plan that it was not legal. Despite knowing that the plan was illegal, Trump pursued it anyway, including for the 187 minutes when the attack happened. Congress was being evacuated to underground tunnels, and even after he was aware that the mob was chanting about hanging Mike Pence. Count 3 of the criminal referral refers to a conspiracy to make false statements under 18 U.S.C. 1001. This is the classic lying to the government provision. And this count was about Trump conspiring with other people to submit slates of fake electors to Congress and the National Archives. These certificates were patently false since Biden won each of those states, and the state's authorities certified Biden's victory. Now, in fairness, whether a statement or act is material for the purposes of Section 1001 can be a contentious issue. But here the report says that at best, quote, it can hardly be disputed that the false slates of electors were material, as nothing can be more material to the joint session of Congress to certify the election than the question of which candidate won which states. Indeed, evidence obtained by the committee suggests that those attempting to submit certain of the electoral votes regarded the need to provide that material to Vice President Pence as urgent. But the bigger question is whether the various people making the certificates and submitting them acted knowingly and willfully. Some of those individuals who signed their names to fake certificates said that they thought that they'd only be used if Trump prevailed in litigating in their states, paving the way for Trump's win in those states to be certified, making their fake certificates valid and okay to submit to the National Archives and to Congress. But that's not the case with most of the executive branch here, since Trump, acting through his co-conspirators like Eastman and Cheeseborough, relied on the existence of those fake electors as a basis for asserting that the vice president could reject or delay the certification of the Biden electors. The people who believed that they were serving as alternate electors in case Trump prevailed in court might not have known that Trump and Eastman were collecting the certificates for another reason, to persuade Pence to implement their illegal plan. But the committee alleges that the higher-ups, including Donald Trump, knew what they were doing and personally participated in this plan. Quote, the evidence is clear that President Trump personally participated in a scheme to have the Trump electors meet, cast votes, and send their votes to the joint session of Congress in several states that Vice President Biden won. And then his supporters relied on the existence of these fake electors as part of their effort to obstruct the joint session. And to prove an overt act in furtherance of a conspiracy, the committee relies on the testimony of Republican National Committee Chairwoman Ronna McDaniel. She told the committee that Trump and Eastman directly requested that the RNC organize the effort to have the fake electors meet and cast their votes, and that she complied with their request. And then the fourth count of the criminal referral is for inciting, assisting, or aiding an insurrection in violation of 18 U.S.C. 2383. Until the events of January 6, 2021, there had been no prosecutions under Section 2383 since the Civil War. The insurrection statute was enacted in 1862 as a precursor to the Emancipation Proclamation. And there was an 1863 Circuit Court case that held that the act was unconstitutional because it punished the same conduct as treason, and treason was only applicable if a foreign country levied war against the United States. Since 1863, the Supreme Court has implied, but has not yet ruled, that it would reject the insurrection as an end run around treason argument. President Trump was acquitted of incitement to insurrection in his second impeachment trial, but since this was not a judicial trial, there's no double jeopardy problem. However, it's not easy to get a conviction under the statute because it implicates the First Amendment. The committee relied on a recent court opinion to assert that Trump's speech wasn't protected by the First Amendment. In Thompson versus Trump, a judge on the DC Circuit ruled that the statements Trump made during his ellipse speech before the riot, quote, were plausibly words of incitement not protected by the First Amendment. This was a civil case where 11 members of the U.S. House of Representatives and 2 Capitol Police officers sued Trump seeking damages for physical injuries and emotional distress from January 6th. The court ruled that Trump would not necessarily be able to invoke presidential immunity in defending the claim. But you can imagine something that is arguably political speech is going to receive the highest amount of First Amendment protection, so we'll see how this one goes. The committee argues that it doesn't need to prove that Donald Trump was actually in contact with the actual rioters, or that there was evidence of an actual agreement between the president and the rioters. Quote, the president need only have incited, assisted, or aided and comforted those engaged in violence or other lawless activity in an effort to prevent the peaceful transition of the presidency under our Constitution. But as an interesting coda here, although the congressional criminal referrals carry no legal weight, Jack Smith, who Attorney General Merrick Garland appointed as special counsel in charge of looking into these crimes, at least as it regards Donald Trump and others in that orbit, sent a letter to the select committee requesting all the panel's materials from the 18-month probe. So the special prosecutor is looking into the evidence, if not the referrals themselves. But if the DOJ picks up the criminal referrals, whether they convict on any of these counts will largely depend on whether they can prove Trump's mental state. And luckily I made a video all about whether Donald Trump has the criminal intent necessary for conviction, but you can only see it with today's sponsor, CuriosityStream and Nebula. Because on Nebula, my videos always come out early with 0 ads. And I release exclusive content all the time, like this video that is exclusive about Trump's mental state. It was hard to make. Some would say, what mental state? Or an entire video about legal stories that are not safe for work because they're too hot for YouTube, as well as exclusive videos like things people misunderstand about the Constitution, why NFTs are bad for creators, and my first full-length documentary, Bad Law Words Good, and tons more, all exclusive to Nebula. Because Nebula is creator-owned and creator-operated, there's new exclusive content released every single day. In fact, Johnny Harris just signed with Nebula, and you can see all of his videos a week early only on Nebula first. And by the way, we've been developing Nebula like crazy. Nebula now has apps for iOS, Android, Apple TV, Roku, Fire TV, Android TV, and it was recently nominated for its 2nd Streamy Award. My fellow creators and I really care about Nebula, and we're thrilled to be partnering with CuriosityStream because they're the go-to source for the best documentaries and long-form educational content on the internet. They even have an entire section devoted to unsolved mysteries and crime, so if you like my videos, you'll love the thousands of titles on CuriosityStream. But the best way to get access to Nebula and all of this incredible content is through the amazing CuriosityStream Nebula bundle deal with its current sale of 42% off. That's less than $12 a year to get access to both sites. And to be clear, that Nebula subscription is not a trial, it's free for as long as you're a member of CuriosityStream. There just isn't a better deal in streaming where you get 2 great streaming sites with content that you'll actually watch, all for less than $12 for the entire year at its current sales price. And it's 42% off. So all you have to do is click on the link that's on screen right now or down in the description to get 42% off both CuriosityStream and get Nebula for free. So just click now on the link that's on screen or down in the description. It's a great way to support educational content and get tons of exclusive content that you'll actually love. So click right now. And after that, click on this playlist over here for more Legal Eagle, or I'll see you in court.